This is Kristen Ishihara and Chris Parker. We're with Ishihara and Parker Law Firm here in Longview, Texas. And this morning, we just wanted to get up early on a Friday and talk about how to own bank accounts. So, Chris, anything you want to add to start with?
Yeah. So we actually see this a lot. People come in a panic. Their loved one, usually it's a parent, sometimes it's a spouse, but usually it's a parent, has had some kind of medical event. They're at the hospital. They're looking at some kind of assisted living, some kind of rehab days at maybe at a long-term care facility, and they're suddenly thinking, hey, wait a minute now. Mom or dad or they have their own funds, but how do I get to them? What should I have done? What have we already done? And I ask them, let's talk about bank accounts. How do they work? And usually they stare back at me and have no clue as to how any of that was set up. So we're going to run through them all, kind of give people ideas of what they may have, what they may want to consider, and what they may want to change.
Yeah, absolutely. And another time that this comes up often is just at death. So, how will my children have access to pay for a funeral or final expenses? Or, if I am setting up my retirement plan, we always ask people, okay, how are your bank accounts owned? Because in Texas, under Texas law, it's a statutory provision. However your bank account is set up, that will control over your will. It's in the Texas Estates Code, the various options on how a bank account can be owned in the state of Texas. And whichever one you choose will govern what happens to that bank account when you die. And most people, when you ask them, how is your bank account owned, they just don't know.
Right. So let's just be clear. If you write a will and your will says it goes to Jimmy, but you have a bank account and the bank account says it goes to Sarah, the funds in the bank account will go to Sarah despite what the will says. I've seen many folks not understand that. Well, I've got a will. I think I'm done. They do not understand that the beneficiary designations or co-ownership terms would control where those bank account funds go.
Right. So we're not recommending one way over another. We just simply want you to understand what the options are, select the right one for you, and make sure that it is correctly designated on the signature card at the bank. That is where that needs to happen. A lot of these topics we'll talk about also apply to other financial institutions, but for today, we're just going to talk about bank accounts, just your checking, your savings. What does your signature card say after you set up the account? And maybe that was decades ago, so maybe we just really don't remember. But anyway, so let's start with the types of accounts we have in Texas, the way that I could own a bank account. Number one, a single party account without POD. Chris, what does POD mean?
Payable on death. When you have a payable on death, that will control what happens to it. So, single party account without POD means it is my account. I am the only person on it. I can control the account. If it's a checking account, I can write checks on the account. So, if my dad has a single party account with no POD, can I help him with that account?
No.
Right.
Now, I may be the financial power of attorney, so perhaps I could bring that to the bank. It could go through their legal review, and maybe I could get some check writing authority. But a single party account means only one party can access it. Only one party can write checks or deposit checks. And then POD, we might often use the phrase beneficiary as well. So we might interchangeably use POD or beneficiary. Sometimes it's called a TOD at a financial institution for transferable upon death. But those are all the same concept of the institution has on their contract with you, your account agreement, who it will pay at death. So that's what we're looking for. Now, estate planning wise, there's pretty limited situations where you might have a single party account without a POD. And that would be a time maybe where we know that your will is going to have to be probated, and we'll cover what all that means in a different session. But we want that single account, whatever funds are in there, we want that to come into your estate. Maybe that's because we have minor kids and those kids are funding trusts through that will. Maybe I need to make some specific bequests. So maybe my will says I give $10,000 to my church, $10,000 to my favorite animal shelter, and then everything else this way. So I need to bring some cash into my estate. Maybe that's a reason why I would do that.
Let me just say, when we say estate, we mean those funds, can't transfer on their own. So then it would pour into the estate, which is governed by your will. So with no payable on death, if there's no POD on that bank account, and you're hopefully doing it on purpose, then you're intentionally wanting those funds to be handled through the probate process in the terms of your will. Like you said, do I have a minor child? Because if I'm a single person and I want to leave everything to my son Timmy, and Timmy's 8, well, I certainly do not want to name Timmy as the POD beneficiary because he would be a minor. And that would create all sorts of issues that have to be handled. I'd much rather have just it in my name, single party account, pass away, and that will I wrote, which is going to have protections for Timmy, would take over.
Right. So there might be reasons that you have your account set up this way, but let's talk about the cons, because I think there are a lot of those on this particular type of setup. So with a single party without POD account, that account will freeze at my death. That means whatever things I have automatically set up to deposit or withdraw, those will freeze on my date of death, and no one will have access to those funds. No one will have access to those funds until my will is probated. I've hired a lawyer. I've had a hearing in front of the local probate judge. I've become the executor, and I present those letters testamentary, that death certificate, to the bank. So you're probably talking 60 to 90 days before those funds are withdrawn from that bank and put into an estate account. And we just want to make sure that you understand that as part of your plan.
And that's here in East Texas, where we have pretty quick courts. There's other parts of the state where you're looking at 12 months.
Absolutely.
So we've seen many families shocked. Like, well, all the money's in the checking account. We just want to, pay the bills and distribute. And I'm like, well, that's not happening. The bank, following its duties, its rules, has locked the account. No one's getting in there without court permission.
Right. So maybe the right solution for you, but make sure that you've thought through the cons of having that type of account set up so that you can prepare for those in other ways. Yep. Next option, single party account with POD, so with a payable upon death. Comments?
Like them. They're great for most times. It's my money, and when I pass away, it goes to my adult, healthy children. And that scenario is what happens. It's worked out real well. I've seen some people set these accounts up like, hey, I've got my will, I've got a lot of things that go through my estate, but I didn't buy a prepaid burial, so I set this account aside and I'm leaving it to my oldest son to pay for burial. Now, that's not part of the banking rules. That money would go to your son. The purpose in which he uses it needs to be told and explained and hopefully followed. But I've seen those kind of simple planning. I've seen people do, advanced estates, and they may not want one account to be in there. They may have a trust and may not, for whatever reason, want that account handled. They want it separate. They'll literally have an account alone with a separate beneficiary that's kind of private and not known by everyone else. I have seen that before.
Sure, absolutely. Yeah, I would say the pro is that it is not part of your estate, so it does automatically transition to whoever you've listed as the beneficiary, assuming they're alive and able to present themselves to collect those funds. The cons, some that follow from the original single party account, are it does again freeze at your death. So that account is closed the day you pass, the income, expenses all freeze, and then that beneficiary can again not access funds until they can walk into the bank carrying your death certificate. So in the state of Texas, that's probably 4 to 8 weeks away. So again, that may be totally fine. You have set it up to go to them automatically. They do not need to probate your will to gain access to those funds, but those funds will not be available to them to pay for your funeral or other final expenses. They will have to wait until they're able to present a death certificate, and that will just in and of itself build in some time that they will not be able to access those funds.
If you're using this account to make reoccurring payments for a third party and they're dependent upon that, that can be dangerous, or at least problematic for that beneficiary.
Right. It's just, we don't really care or advise you to do it a particular way, but think through, if I have a car note that's being debited out of this account, if I have my mortgage that's being debited out of this account, let's just say we have one child. That one child is going to have you pass away, have your account freeze, and now have all of these bills that have been not paid that they are trying to figure out how to cover with the estate out of their own personal funds in addition to paying for a funeral. It can be overwhelming,
stressful,
right? So we just want to make sure that you have thought through all the options, know what the options are, and make the right selection for yourself without us really recommending one over the other.
And of course, just like anything else, when you're down at the bank, they will talk to you about all of this. They have forms like you wouldn't believe. So if you have questions, definitely talk to your banker when you're down there.
Yeah, certainly. Next option, a multiple party account without right of survivorship.
Okay, so 2 people are on the account or more. Any one of them can write checks, deposits, withdrawals.
Withdraw how much?
Unlimited?
Unlimited, 100%.
So in other words, if I was saying, hey, I've gotten older, I'd like some help, so I'm going to put my adult child on my bank account, right? It's no longer a single party, now it's a multi-party account, and I've added my most reliable child. That does a couple things. Most reliable child can write checks, make deposits.
Get online access.
Do withdrawals, make sure I'm not being scammed. Okay. Now, my adult child and I have very different lifestyles, though. I'm older. I don't travel much. I have low miles. I engage in low burn activities, I guess you'd say. My adult child has a risky lifestyle. He or she drives everywhere, hangs out with their friends, does all sorts of crazy, wild things. Is that a problem or potential problem?
Well, you and I probably have a little bit of a different opinion on this one, and it is going to be very fact specific. So we are not recommending or not recommending that you add somebody as a joint owner on your bank account. Chris's concern is that if I add, say I'm a single person and I add my adult child as a joint owner on my bank account, we both own 100% of what is in that account. We could both withdraw 100%. That means that even though my child may not come take 100% of the funds out of there, if that child were involved in a car wreck, involved in a child support suit, involved in anything that gave them some liability, that asset is owned by them, even though they contributed $0 to the account, and all of it is what you would common sense consider to be your money. You have opened up the funds in that account that your child is now an owner on to anything that happens in your child's life. Now, there is a risk. That is a risk.
I just think of the scenario where, clients older, they're selling their home, the proceeds go into the bank account, and, they happen to share that account, multi-party account, with their adult child who got in an accident while drunk. Never want that to happen. It just concerns me that your life assets could be at risk. So I'm a big proponent of saying, hey, I've got a smaller daily checking account that money goes in and out of, and I have help on it, and that is my adult child. And maybe I have another checking account or savings account that is just mine only for the larger sums.
Yep, I think that's a great solution there. So if you use a multi-party account, then what are the benefits? We've talked about the negatives. What are the benefits? Yeah. The benefit is if I pass away, my child who jointly owns that account, the account now remains open. It does not freeze at my death. The child has no delay in accessing those funds, so can immediately pay for my burial, can pay for any expenses that have come up upon my death. They do not need to bring they eventually need to bring a death certificate in, but they can immediately continue to use those funds, no delay. It's the easiest possible setup for that adult child, in my opinion. Is it right for you? Maybe not. A good medium ground there is probably, if you are going to have a child on as a joint owner, just be aware of how much you keep in that account. It does not need to be all of your life savings, because that has significant cons in that the child could have liability. It also means that that one child owns everything in that account at your death. So if your original intent is to split things equally between 3 children, you've left 100% of what is in that account to one child who may or may not do the right thing, but I guarantee you we've seen it go either way, and it's probably 50-50 split.
How many times have people came in with a will that says everything I own is split 3 ways, and I will follow up with the question as, well, what does mom own? And I'll say, well, mom has a checking account, and her life savings are in there, and she owns nothing else, and one of us owns it. And I look at them and say, well, okay, the will's very clear, but under the banking rules, they're going to write a check to you, or they're going to leave you on the account alone. It's for you to divide after that, and that's when you have some real character testing among the children.
That's right. Yeah, and I truly would say my guess is about 50-50. 50 do what parents wanted, 50 do what is legally the correct answer, which is they are 100% the owner. And people would explain that as well. Mom knew what she did when she set that up because she read the signature card, which we are suggesting you read the signature card and understand the consequences of it. Next option, multiple party account with right of survivorship. We've kind of covered this one a little bit. Anything you want to say about this one?
Nope. Definitely works great for the right situation. Not minor children, not disabled children.
Yep. In fact, that's actually the one that I already talked about. A multi-party account without right of survivorship would not go to the surviving child, but they would be able to direct it you would need to have a multiple party account with right of survivorship for that to belong to that child, which is actually what I just talked about. So I kind of merged the two, sorry. You don't see a lot of multiple party accounts without right of survivorship. That's somewhat rare and was previously used when you had a taxable estate planning. So I would say we don't see many of those now. If you set it up that way, you are probably doing it with right of survivorship, but that is the question to ask and a box that you probably do want to check there. Multiple party account with right of survivorship and POD. Same concept we've kind of talked about already. So it would just be, this is pretty common. Let's say I'm still married, so I have a joint account with my spouse. We have right of survivorship between the two of us. We've listed our 2 kids equally as POD.
Or 2 adult children that are healthy.
Yeah, correct. Yes, no minors listed. And again, going to freeze when both of you die, but as long as the kids have access to pay for your funeral in another way, aren't financially strapped themselves, that's probably going to be an okay way for you to set it up. You certainly want to make sure that your surviving spouse has immediate access to that account, so probably needs to be on there as a joint owner as opposed to a beneficiary, but again, for you to decide.
And also, just as an overview, or just a thought, some of y'all probably divide your duties up, right? Like someone, either, maybe the wife's running the finances, has all the bank accounts, knows where they're all at, handles all that stuff, and husband doesn't do any of that, or vice versa. You better have this written down somewhere. I've seen many spouses come in who are just distraught over the loss of their loved ones and have no idea what they own, where they own it at, how to access it, what the account numbers are, or where the cards are. And that's hard. There's no master list we can just access.
There's not a blacklist that we access on the internet that tells us what you own.
It doesn't do it. You have to literally wait for your mail to come in. You have to look through that wallet or purse looking for different cards to go to those accounts. So if you're one of those folks who does all the finance, please make a master list. Keep with your probate, document your wills, your power of attorney, but make a master asset list so that your spouse isn't chasing, breadcrumbs all over the place. Make it easy for them. Absolutely.
That's a real kindness you can do to whoever your beneficiary is going to be, spouse or kids, certainly. Next on our list, a convenience account. Tell us what that is, Parker.
Convenience accounts. It's where we're using, I think, mostly our powers of attorney. So it's my account, but I have my adult child who's my power of attorney on that account. So my adult child can write checks, can help me balance it, can make sure there's no transactions. But if my adult child gets sued, it's not an available asset to their creditors. It's not their money, it's my money. It's my money, but I'm getting help with it through the agent we've named.
Right. It's what you would commonly hear referred to as a co-signer. So it'd be similar to the way we would think about a financial power of attorney would manage an account. It is, I would say, the most commonly confused. If I ask a parent who's there with a child, is she on your bank account? And they say yes. And I say, is she on there as a co-signer or a joint owner? Typically, we don't know. So this is the one that I really want you to focus on and nail down. If you have taken your child to the bank and said, bank, I want you to add this person onto my account, how are they on there? Are they on there as a co-signer? Because that ends at your death. You no longer have the ability to authorize someone as a convenience or a co-signer because you have passed away, your authority has ended. Or did they get put on there as a joint owner with right of survivorship? That would be really important to understand because either they're going to still own the account and have access to it, or their access is going to end at your death, the account is going to freeze, and then you probably want to make sure that you have a POD on that account as well. So could you have a co-signer and then a POD? Absolutely. Is that a good solution? It might well be. To Chris's point, this does not make any of your account subject to a child's liabilities. They are only managing it with your authority.
Yeah, and I think as you're going through these types of accounts and thinking about them, you can see it's clear. You can either have access and control, or you can have ownership. And in the courts, the law has made it very easy. You either have convenience or you have safety, but it's hard to have both. You got to choose which way that's going to work for you.
Well, actually, let's talk about our next option here because I do think that this alternative provides both. But it is an estate planning tool. So the next option on the list is to own that bank account in a trust account. Can you tell us a little bit about what that would mean?
Sure. So this isn't where you just simply go down to the bank and say, hey, I want to put this account into a trust account. You have to generate or create the trust in advance.
Right.
You are saying, okay, I met with the attorney, my estate planning attorney. I am, everything we own, if we're a married couple, is going into, let's just say, a living trust or revocable trust. It's going to be owned by both of us. Upon the death of the first of us, the survivor gets it. Upon the death of the survivor, it goes to the 2 kids 50-50 down bloodlines. That's pretty standard, easy planning. So what you would actually do is you see the estate planner, you create the trust, whatever it needs to have, and then you actually go down to the bank. You're going to take the certificate of trust. They may need some certain pages from the trust itself to actually place the ownership of the bank account into the trust.
Yep.
In fact, your check faces may change. They don't always have to, but it may have, my family trust, though you may be able to leave it the same too. That actually changes the ownership at the account out at the bank to be controlled by the trust, which means a trustee manages the trust.
Right. And this may be more planning than you want to do, and that's fine. That's why we've given you the other options clearly. But I do think a trust does answer most of the concerns that we've brought up. So if I have set up a revocable living trust, I'm essentially creating my estate during my lifetime. So I've moved in there my house, I've moved in there my personal property, I've moved in there my checking and savings account. That means that the terms of the trust control what happened if I'm incapacitated or I'm deceased. And the trust will say, this person is the successor trustee. These people are the beneficiaries. So if I have moved my general operating checking account to be owned by the trust, managed by me as trustee while I'm alive, but I pass away, the terms of the trust immediately move my child or whoever it is up to successor trustee. That successor trustee can immediately use the funds in the bank account because it's in the trust. Then they can use those for your funeral, final expenses. Then the trust says who the beneficiaries are. So the trustee, after paying final expenses, sends it to the 3 kids in equal shares. So it's not owned by just the 1 kid that I've put on there as a joint owner. It's correctly designated who the beneficiaries are. And it's also not owned by that child. So it alleviates all of the concerns that Parker was addressing, that would be subject to a child's liabilities. It's owned by the trust, which is me during lifetime, but I've put in place for immediate handling when I pass or I become incapacitated.
So I have a disabled child. That disabled child is dependent upon my checking account for their well-being. I could consider creating a trust, placing the account into the trust, the ownership of the trust. It owns the account. The trustee manages it. I pass away. My next successor trustee would take over and provide funds pursuant to the trust for the benefit of my disabled child. Same thing for a minor child. That would take the delay out, the 6-month delay, the year delay, depending on where we're at.
Right.
That would allow a smooth transaction, clear.
Yep. And sometimes just the use of the phrase trust account confuses people. This is still just a checking or savings account owned by your trust, managed by you as trustee. So it's simply just the way they fill out the signature card. It's not, you've gone to the bank and talked to their trust department. That is a totally different thing. You are still the trustee. You are still in control of it. It is just owned by the trust that you still control and during your lifetime are the beneficiary of. So we don't want to be, the terms seem sophisticated, but they really just come down to the way that we filled out the paperwork. So can be a good solution, is not right for everybody, but hopefully this will have provided you some good information on what is right for you. And if you have additional questions, feel free to reach out to us. Feel free to sit down with your bank. The information we're providing today, except for the trust, is just selections you are making at your financial institution. Those are not selections you need to make with your lawyer. It is, however, part of a comprehensive estate plan, so you do need to understand how those accounts are held, how they will be managed in the event that you are incapacitated, or what will happen when you pass away, just to make sure that it all lines up with how you want things to go. Anything else you want to add?
Nope, perfect.
All right. Well, thank you so much for joining us today. You can find additional information in our notes below. Please like and subscribe our channel. Thanks, guys.